And this is great. There we go. So this is something we're all familiar with, how to dissect a case when you first get it, but we're going to be a little more hands-on with that one. We're going to do some brainstorming and we're going to run through some different scenarios of the best ways to get what you need out of a new case. And then the second thing we're going to do is we're going to talk about the results of a judge's survey that we conducted a few years ago so that we can sort of have an open forum to discuss some judges' preferences in mock trial. And like we mentioned in the main session, some of these, can contradict each other, and some of them really all judges have the same opinion, but it really is for discussion purposes, and especially so that y'all can ask questions. And before we get going, just to make sure the chat is working, and you'll have the option of either putting questions and answers in the chat, or you can also raise your hand and then unmute yourself and we can just talk. That's fine too. So whatever you're comfortable with. But to get started with the chat, if everyone can put in the chat, let's say your favorite color. And I'm going to put mine in there too, just so we can make sure we're all there. All right, I think we got every color under the rainbow, which is great. Okay, so the chat's working. I think the PowerPoint is working, and off we go. Okay, so the first things that I want to go through are basically what it means when you get a new case and what you're going to want to prioritize and maybe not spend as much time on. So first of all, everything is included in the case for a reason. Now, I have not personally participated in writing a case. I do that on purpose because I'm a presiding judge in almost every trial during the mock trial, and I don't want to be influenced by what the committee has thought about as they're writing the case. I really want to come in there blind, so to speak, so that I can see what y'all are going to do with the case, as opposed to what we might think are right or wrong. But I do know that for the people that write the case, that there is nothing in a case or in any of the witness statements that doesn't have some sort of purpose. Kevin, I know you do participate in writing the case sometime. Is there anything you want to say about this?
Yeah, no, you're absolutely right. I mean, everything is in there for a reason. Um, some things may be designed to maybe lead you down a path that may not be as fruitful as other things. And it's up for you, and it's up to you all to read it and try to understand it and figure that out for yourselves. So. I'm when I'm a scoring judge, or when I'm a presiding judge, I agree with Jamie. Like, I don't typically read it beforehand, even though I may have written it. Um, my job is to hear how you guys and how you as your team and as advocates present the evidence in your arguments to the court. So that's I everything Jamie said I agree with so far.
Yeah, and then another thing, as I'm sure you all know, is that you have limited time at trial. And I know the time goes really, really fast when you're presenting. And so it'll sometimes happen, and this happens to us too as attorneys, that you get bogged down in trying to get the right answer to a question from your witness or trying to make a point that you think is really important. And sometimes then you look at the clock and you say, oh my gosh, 10 minutes have gone by and I only have 5 minutes left for this examination. And maybe you did end up getting that question answered, or maybe you didn't, but you spent 10 minutes on it. And so that's something that everyone should be aware of, both attorneys and witnesses, that if it seems like something is taking a while to do, keep in mind that the time is moving even slower for the judges because you're there, you're in the moment, and time is moving very, very quickly as you're trying to get everything in. For us, if it feels like you're struggling with a question answer back and forth, that time is going to feel even longer to the judges. So really think about that. Sometimes it is worth, if you're not getting the answer you want, but it's not a question that is really, really important to your case, sometimes it makes sense just to let it go at that point. But let's talk about case organization. So we're going to talk about what a proof chart is, and this is one really good way to make sure you have everything in the case accounted for and that you're able to ask the questions and give the answers that are necessary to prove every element of the claim that you need to prove. So let's move ahead. Here's the case that we're going to be working with today. And this is very bare bones. So there's going to be a lot of stuff missing necessarily because this is just for the clinic. But generally, what we're going to be talking about today is an employment dispute. And our plaintiff, Jess, has been employed by Cafe Bonjour since 2020. And she was hired to bake breads and pastries. And upon hiring, the cafe required her to sign an employment agreement. Now, the couple of things that the agreement specified, and of course, an agreement would have a lot more stuff in there, but this is what's really relevant today. So the initial term of employment was 1 year, and then the contract would continue year to year unless either party terminated the employment. Jess was entitled to terminate employment or quit for any reason by providing 2 weeks written notice to the employer. The employer could terminate employment for good cause at any time with no notice required at all. And then we get to January 2024. Jess shows up to work, and the general manager of the cafe says, "You're fired." And the reason that the general manager gave is that Jess forgot to write happy birthday on a cake that a VIP or very important customer ordered the previous week. So Jess made a mistake, and there's no dispute about that. Everyone admits that there was a mistake made. After Jess was fired, she couldn't find another job that paid her as much as her employment at Cafe Bonjour. She couldn't pay rent anymore, so she moved back in with her parents and had to sell her car to pay for food. And so that is the very basic fact scenario that we're going to be talking about today. Now, first of all, I want to ask all of you, and if you want to put this in the chat or raise your hand, what other facts would you want to know if you were trying this case? Because like I said, this fact pattern on the slide is very bare bones. But as an attorney, or if you were going to be the witness playing either Jess or the general manager, what other facts would you want to know? And apparently the chat gives us a bunch of birthday cakes when someone writes happy birthday in the chat. So that was fun. I don't know if everyone saw that. Okay, so Keller said, was it required in her contract to write happy birthday? Yeah, that's important. We don't know enough about the contract to know the specifics of what Jess was required to do. All that we know is the contract hired Jess, and it spelled out some terms about how the contract could be terminated, but it didn't say, okay, you have to follow a customer's order to the T or else you risk being terminated, and that the employer could call that good cause for termination. So that's an important question. Has good cause, oh, go ahead.
Oh, sorry. I was also gonna kind of throw in one question that it's definitely along these lines is there a difference between writing happy birthday and baking and actually physically baking bread and pastries? That's a thought that came. That's another question that we just don't know.
Right. Yeah, exactly. So something we would want to dig into, something that one of the fact statements would probably give us more information about. So Mark said, has good cause been defined in the contract? Yeah. And as attorneys, good cause is one of those standards that is very nebulous. Like it can mean a lot of different things in a lot of different situations. So in this context, we would definitely want to know, what does it mean for the employer to have good cause to fire Jess? And it could be defined in the contract. It could be that the case law around employment in this state defines it for us, or it could be something that the jury needs to decide what good cause means. But that's certainly something we would want to know. Mark also said, does she have a track record of making mistakes? Yeah, that could be something we'd want to know too. Is this the 15th time that Jess provided a cake that wasn't correct? Or is this the first time ever that this has happened? And that could definitely go to whether there was good cause for Cafe Bonjour to terminate the employment. Any other facts that we think are missing here that we would want to know before we proceeded to create a proof chart? Yeah, what defines a VIP customer? If it had been just somebody off the street that came in and wanted a birthday cake and just messed up the cake, would that have been good cause for termination? Or is the fact that it was a VIP customer, maybe somebody who comes into the bakery every week, or somebody just with a lot of money that can really, or an influencer, something like that, who can really make or break the bakery? Is that the kind of person that Cafe Bonjour really doesn't want to offend by giving them less than perfect product? So that's a good question too. Is Jess allowed to sue for wrongful termination? Yeah, that's a really good question too. And in a bigger fact pattern, I feel like that would be a big part of this case as well. That Jess is going to sue Cafe Bonjour, and it's going to be a breach of contract case that we're going to talk about here. But is there a wrongful termination claim as well, which could give Jess the ability to collect more damages, or bring in some other witnesses that might talk about if Cafe Bonjour had done that to them in the past, other things like that. So that's a good question. Anything else? Okay, and we can come back to that, but let's move on for now. So we're talking about a simple contract case here, and we're not going to go into the law too much, but basically, for any case that you're given, you're going to want to break down the elements. And the case is going to tell you here are the elements that you need to prove or disprove, depending on what side you're on. So in this case, the plaintiff would need to prove that the employment contract was a valid enforceable contract, because in contract law, that's the very first step that you need to prove, is that a contract actually exists. And then next, did Cafe Bonjour breach the agreement when it terminated Jess's employment? And Cafe Bonjour will say, no, there was no breach there. We did what was allowed under the contract. And Jess's argument will be, yes, they breached the agreement. They did something that was not permitted under the contract. And then the last question, and something that usually doesn't come into play in mock trial, but is important in regular trials, is did Jess suffer damages? And were those damages part of, or were they the result of the termination? Because it could also be that Jess is a gambler. Jess goes to Oklahoma every weekend and gambles all night. And so the fact that Jess didn't have the money to pay for rent could be because of the gambling. It could be because of the termination of employment. It could be both. It could be something else. But those are the kinds of things that the case pattern will give you. There's going to be a lot of different facts so that you're able to mix and match and figure out what's good for me, what's bad for my side, and how can I muddy the waters on things like this. And then the next thing you're going to want to do, because you're going to be both the plaintiff and the defendant during mock trial, is ask, okay, if I'm Jess, the plaintiff, what am I going to need to do to prove these elements? If I'm the defendant, Cafe Bonjour, what do I need to do to disprove all of those elements? And that's where a proof chart comes into play. But before I move on to that, are there any questions? Or Kevin, do you have anything to add? We're open for discussion.
No, as far as I mean, you've covered everything as far as how what you have to do in establishing those elements, for this type of case. Um, yeah, the it's this, and when you're doing this, you also have to think about how am I going to present this to a jury, as far as in my in my opening statement, how am I going to structure my opening statement to do this? um you know when when I was at trial, for the cases I was trying at the time, I had five elements that I had to prove. So I would basically just, I would go take my hand and be like one, two, three, four, five, something like that, and explain each element by each finger and that sort of thing to just to set the expectation in the jury's mind that these are the five elements and I'm going to cover all five of them at trial. So when you're doing your proof chart, you're helping yourself prepare for the case, but you're also starting to plan for how will you present this to the jury. And that's the next step beyond just making sure that you actually talk about them. It's about how you present the ideas to the jury, who is the ultimate fact finder in this case.
Yeah. Yeah, absolutely. And in mock trial, this comes into play a bit. In actual trials, we have something called a verdict form that goes to the jury. And the verdict form will have every cause of action and whether you as a juror believe that that cause of action was met or not met. And then they'll have a line for damages. How much damages if you find that the contract was breached? How much damages do you think the plaintiff is entitled to? And so it really is just a piece of paper that you fill out as a juror. And so Kevin is absolutely right that you do need to think in terms of, okay, we're breaking down the case, we're figuring out how to prove all these elements, but let's also tie it in to what the jury is eventually going to be seeing by the end of the case. And so it's really helpful to be able to do that. Okay, so let's talk about the proof chart a little bit. So this is the proof chart for the plaintiff in this case. So this would be if you're representing Jess. So the first element, like we talked about, is the agreement valid and enforceable? The second element is, did Cafe Bonjour breach the agreement? And the third element is, was Jess harmed by the breach? Because we need that to prove damages. And it needs to be not only that Jess, like I said, suffered damages, but also that it was Cafe Bonjour's breach of the agreement that caused those damages. That's very important. Okay, so let's talk about each one of these. So first, is the agreement valid and enforceable? And I'm going to go back to the case slide so we can think about that. Is there any evidence given from this scenario that goes toward, yes, this is a valid contract, or no, this is not a valid contract? So one thing I'll mention, and again, we don't have a whole lot of facts here, but from what we do have, we know that Cafe Bonjour required Jess to sign an agreement, but we don't know if Jess actually ever did sign the agreement. And for a contract to be valid, it needs to be signed. We also don't know if Cafe Bonjour signed the agreement. So those are the types of facts that if we knew that Jess signed the agreement and it was fully signed, then that would go toward, is this a valid contract? Is there anything else in here that folks see that might go toward, okay, this is a valid contract or this is an invalid contract based on what we know? Okay, so we can come back to this, but not really. Yeah, and if, okay, so the question Keller asked is, if both parties are acting like it is, can we assume the contract is valid? So that would be the law that you're given in mock trial. It might not necessarily be the exact law of contracts, but generally, if both parties are acting like a contract is in place, then they might have an oral contract too, and those can also be binding.
Yeah.
So
Now,
go ahead, Kevin.
sorry, I was just going to say that for like in the mock trial context, that's probably something that might be stipulated to in the stipulations in the case stipulations, and that's why those case stipulations are important because they help establish what you do and do not have to prove at trial. So that's one of those things that would probably, I think, in writing this case out, if I'm thinking, if I'm putting my case writer hat on, I would probably want that stipulated that we're not having to address whether or not the contract was valid or not. Um, that sort of thing. So that's why those stipulations are there. They help put guardrails around what we want you to prove or not have to worry about. So FYI.
Yeah, and then Dakota said Cafe Bonjour stated that they could terminate anyone at any time. So that's a good thing to think about when you're thinking about, is this a valid contract? Is it legal for Cafe Bonjour to do that? It may or may not be, depending on the law that you're given for mock trial, but that's definitely something to think about, that if Cafe Bonjour wrote a contract that gave them rights that they weren't allowed to have, then it might not be a binding contract at all. And in that case, there's no contract to fight over. And so Jess's case wouldn't be very successful. So then the next thing we'd want to talk about is, did Cafe Bonjour breach the contract? And do we see any evidence for the contract said X, Y, and Z? Cafe Bonjour did something they weren't allowed to under the contract. That's a breach. So do we see anything in this fact pattern of Cafe Bonjour breaching the contract? Or on the other side, do we see anything about Cafe Bonjour not breaching, doing what they did, but it was permitted under the contract? Okay, so Don said, why did it take a week to fire Jess? And that is definitely something that would be covered in the witness statements. There would maybe be other testimony that comes in about this. But yeah, because at some point, Jess is thinking that, whoops, I made a mistake, but that it must not have been that important because I haven't been reprimanded, nothing has happened, my job is okay. So that's definitely something we'd want to keep in mind too.
Now, the caveat to that is that is a good question. It just, in looking at and reading the third bullet point, so it says that they could terminate employment for good cause at any time. So given the fact that you do have a limited amount of time at trial, that is something that you could bring up in probably one question. But if you spend too much time on it, given the fact that you probably that there is pretty solid evidence in what you've been provided, that it can be done at any time, you might want to consider how you allocate that question in consideration of the other things that you may want to try, that you have to prove, or you may have stronger evidence for. That goes back to overall advocacy. So, anyways.
Yeah, yeah, definitely. And then here, when you're talking about breach of contract, you really want to focus in on the good cause. And what does good cause mean? Did Cafe Bonjour firing Jess because she forgot to write happy birthday on a cake? Is that good cause? Because if it is, then there's probably no breach of contract. If it is not, then there probably is. And then Keller said, in the contract, does it say that the cafe can move immediately to termination before verbal reprimanding or any other type of corrections? That's a great question. And I'm sure in an actual mock trial, that contract would specify if that's okay or not. Because, yeah, if the cafe was required to tell Jess, hey, you messed up, and if you do it again, you're going to get fired, then if the cafe didn't do that, it would be a breach. So that is certainly something we'd want to know. Okay, what do we think about damages? And we talked about this a little bit, but is Jess able to show, or, and that's something we'd want to think about, is Jess able to show that the damages that she suffered by not being able to pay rent, not getting another good job quickly again, was due to her being terminated by Cafe Bonjour wrongfully. And we don't really have enough information here because, like I said before, it could come down to another number of other factors that she wasn't able to pay rent. And those are all things that will be in the witness statements to try to make it a more complex case. So Maria said, is it in her responsibility to have written happy birthday, or is she just in charge of baking? Yeah, that's another really important piece of this. There could be another person who does the icing of the cakes, and it's their responsibility to write happy birthday, and Jess is just the baker of the cakes. Or it could be specified in the contract that Jess has to do all of this. So that is something that could definitely come into play as we're working through this particular contract. And I'm going to go back to the proof charts for a minute. So the one that we looked at before was for Jess, the plaintiff. And again, these are the three elements that we would have to prove. The evidence, if you're making a chart like this, the evidence column would be to list every piece of evidence that you see from the fact statements that is in Jess's favor. So for example, and I'm making stuff up that isn't in the fact pattern that we saw, but could be relevant evidence here. So like Maria's point, let's say that in the contract, it said Jess is only responsible for baking, but not icing. Then that is definitely something that we would want to put in the evidence column because that's something that would go toward whether there was a valid contract, whether it was enforceable. We could also put in the evidence column the fact that Jess couldn't find a good job after she was fired and couldn't pay her rent. That goes toward the harm or the damages. So all of the pieces of evidence that you think are good for you would go into that evidence column, and trying to break it down by element just really helps keep you organized as you're doing that. And then strength and weakness, you can do this in a number of different ways. You can either maybe have a 1 to 10 ranking that you say, okay, the fact that Jess couldn't pay her rent anymore is really strong evidence of harm. And I'm going to give that a 9. But the fact that Jess couldn't find another job right away, because maybe there's some other evidence that every bakery in town was hiring at this point, maybe that's pretty weak evidence. So you'd want to give that maybe a 3 or a 4. And then you can also go into talking about narratively what is strong about this piece of evidence, what's weak about it, is there another fact that would counter this fact that we're talking about. And so for example, the fact that all the bakeries in town were hiring would be a weakness, and we would want to list that in the weakness column. And then issues, like if there are any other issues that you think are important that we need to consider when we're going through a fact pattern. And so some of those could be, okay, this is a good fact, but it's never going to come in because it's the only way it can come in is through hearsay. Then that's definitely something you'd want to mark in the issues column to be aware of as you're thinking about it. And then let's look at the proof chart for the defendant, and then we'll pause for questions. So if you're Cafe Bonjour here, then the things that you would need to prove are first, that the employment agreement was not valid or enforceable, that you did not breach the agreement, that Jess actually didn't suffer any harm, or if there's other defenses available to you, which there might be. And so, as you know from doing mock trial before, you're going to have to be both plaintiff and defendant. So you have to switch your thinking completely to the other side and start looking at the fact patterns to figure out, okay, are all of the bad facts for Jess good facts for Cafe Bonjour? Are there other good facts for Cafe Bonjour? What are the bad facts? And so basically just doing the opposite for that proof chart. I'm going to pause here. Kevin, anything to add, or are there any questions or anything we want to discuss in the chat?
No, I think everything you said is spot on. In one of the I guess one of the things that may help you as you review, with not only this practice example, but also the actual mock trial case problem this year, is by understanding the case from one perspective, it may help you understand the other side as well, and back and forth. And but the more times you do it that way, it will basically create a feedback loop, which will help you increase, which will strengthen not only one side, but the other side as well. So, anyways.
Okay, then let's move on. And obviously, if you have any questions about anything that we covered earlier, you can put it in the chat at any time. This is not very formal, so we can just go back and forth in discussing things. All right, let's talk about theories of the case. So it's good to have a unifying theory, both as plaintiff and as defendant, that you can keep coming back to as you're arguing your case to the jury and as you're taking witnesses, and if you're a witness, as you're giving your testimony. So, what are theories? Theories are just the legal arguments that prove or disprove the claim. And you want to make sure that your theories are understandable by the jury. And so that's what practice is for. And that's why it can be really important to practice in front of team members who aren't necessarily playing attorneys or witnesses and aren't as close to it as you are, because they're going to be more similar to the jury or the mock trial judges who are hearing all of this for the first time. And they can give you really good feedback on, oh, that was really good, that resonated with me, or I have no idea what you were arguing just then. That question and answer didn't make any sense. I don't understand why it was important. So all that kind of feedback is really important to get. They should also be solid theories that don't have holes in them. Because if you're up against another team that is really effective, then they can turn your theory around on you. And you can do the same with one of your competitors as well. That, if they make this theory about, okay, the theory of the case is that poor Jess, she is not able to get another job. She's living with her parents again. And it's completely due to what Cafe Bonjour did to her. And then the other side comes back and makes a big deal about, hey, Jess is a gambler, and that's their theory. Then it kind of cuts yours. So you might want to go with a different theory that isn't as weak or vulnerable. And it should be easy to remember. It should be something that in real life, when the jury goes back to the jury room to deliberate, they're thinking, oh, yeah, Jess is a gambler if you're on the defense side. And because that's very memorable. And so even in mock trial, when the judges are scoring, that's something that can resonate with us is, oh yeah, that was the team that kept saying how Jess is a gambler. And it really cut open the plaintiff's theory that she was damaged by Cafe Bonjour. So things like that you're able to remember if you're using analogies, if you're using stories, anything like that can be very effective. Okay. And similarly, themes are the memorable sound bites. And most teams are really good at this. But if you do use a sound bite and you use it in your opening arguments, it should be repeated throughout the case, but at least in closing. And so, again, if you're on the defense here and one of your themes is that Jess is a gambler, then you would want to start out your opening about something like rolling dice or spinning the wheel or something that paints a picture for the jury. And then when you come back to closing, you could do something like that again, because it would really help solidify it in the judges' minds that this is what the theme is. The theme is about gambling. It's not about wrongful termination. And so some of the things to think about are, can the theme be used against you? And we talked about that a minute ago. Which theme is best able to stand up to critique? Which of them conveys all the theories most succinctly, and which of them is most memorable? So when your team is dissecting the case and starting to really brainstorm about, okay, what kind of themes do we want here? These are all really good questions to ask as you're working through that. So again, I'm going to pause here for any questions or if anyone has anything they want to add or discuss.
And to complete to continue the thought with themes. Themes are great, especially if you communicate them throughout your presentation of the case. It's not enough to just develop one in practice, which is what this is for. But it's also about making sure that you communicate that in your opening to the best of your ability in your questions and in closing.
Right. And Dakota said Cafe Bonjour could argue that the good cause was not specifically defined in the contract. So Cafe Bonjour can define what mistakes count as good cause for termination. Yeah, that's going to be a really strong argument on the defense if good cause is not defined in the contract. That really does give Cafe Bonjour the right to say good cause is what we think it is. And we think that Jess not writing happy birthday on a cake was good cause for termination. And then Jess, of course, then can come back and say, are you kidding? Of course, that's not good cause for termination. That's a minor mistake that anybody could make. And then off you go. There's all sorts of arguments you can make there. So, yeah, that's going to be one of the really important things. And that could also turn out to be a theme, too. Like the entire case could come down to what is good cause. And the jury would have to decide, oh, okay, I think Cafe Bonjour is right that not doing every aspect of your job perfectly can lead to termination. That is good cause. But then Jess could come back and say, people make mistakes. That could be your theme. Nobody's perfect. People make mistakes. That's not good cause for termination. So yeah, it's a really good way to think about that, but that could lead to some good themes for opening and closing. All right. So let's move on to controlling witnesses, which is, I think, for every trial attorney, for every mock trial attorney, is one of the most challenging parts because you've got your cross examination, you know what you want to get out of the witness that you're crossing, and then the witness just goes rogue. And it can be pretty difficult to get them back to where you need them, which is why when you are practicing and you're figuring out your cross outline, you need to make sure to think about, okay, what are the exact points that I need to get out of this witness? Which elements do they go to? Why is this important? Because you might just get a really difficult witness who is not going to admit to anything and it's like pulling teeth. But if you can get one or two really important admissions out of them, then maybe it's just a really short cross, and that's okay. As a presiding judge, if I'm seeing that, I'm going to really think highly of an attorney who is dealing with a difficult witness like that, kind of re strategizes on the fly, and then limits the cross to the really important points, as opposed to just fighting and fighting and fighting, knowing that you're probably not going to get anywhere. But again, that can be different depending on different judges. For me, and I'll throw it to Kevin in a second, but for me, I want to see how, if you're playing an attorney, if you're an attorney in mock trial, how you deal with things like that on the fly, how you change strategies, things like that. I think that really lends to pretty high scoring if you're able to do things like that. But Kevin, what do you think?
Yeah, I mean, and that especially comes out on cross when it's not your witness. You're more likely to lose points if you can't control your own witness. Normally that doesn't happen, but sometimes it can. But it really comes out on cross when everybody knows what the facts are. So the question is are you asking the right questions to elicit the response that you want the witness to say? And if they're not giving you the answer you want, you have to think about the questions you're asking and making sure that they are couched in a way that elicits the response you want.
Yeah, yeah, definitely. And this is really where practice comes in. And if you're practicing cross, I mean, it's good to be able to practice with an outline, and then one of your teammates is the witness answering the questions like you want them to. But it's also really, really helpful to have a teammate practice with you and try to be as difficult as they possibly can so that you can start thinking about, okay, how am I going to deal with this if this witness just goes completely rogue? Um, because, yeah, there can be a number of different strategies for doing that. Okay, so in the case that we're talking about, we could have some problem witnesses. And so let's say that the witnesses that we're calling in this trial are Jess, the Cafe Bonjour manager that fired her, the VIP customer who ordered the cake, and then Jess's parents, who she's living with ever since she lost her job. Now, if you're thinking that any one of these witnesses could be a problem, why would you think that would be so? Like, what kind of personality traits do you think these people might have? What kind of motivations do you think they might have to be difficult? What could come up in their testimony that would make them challenging to cross examine? And while y'all are thinking about that,
So
Kevin,
yeah,
yeah, go
so
ahead.
yeah, so I posed a question to the participants in the chat box, and if you want to type your responses, please do that. So okay, no, Victoria says so. Maybe speaking about Jess's character, that's no, that's good. Um, and there, that's good. Credibility, okay, good. That could definitely be something that you if you are Jess is a if you're representing Jess, that could be something that you would bring up. What about if you're the attorney for Cafe Bonjour? Okay, Keller says to show that she doesn't need damages. Okay, maybe. Mark says parental bias. Okay. Um, Parental bias. So if by that you mean that that it's basically, just to show that that she's a good person and it's not really relevant to this case. Okay, maybe. Okay. Um, okay, what about the Cafe Bonjour manager? So, do you think the manager would be a problem? And I'll put that in the chat.
Yeah, just to get discussion going, I would think the manager could be a problem if you're representing the manager, Cafe Bonjour, if the manager comes across in a certain way that you know the jury is not going to like. Because sometimes jury trials really do come down to the likability, the authenticity of the witnesses. And maybe the Cafe Bonjour manager, we find out, has fired 20 employees over the past 6 months. And every time it was for a reason like not writing happy birthday on the cake. Then something like that could be problematic if you're representing Cafe Bonjour. But what else do you all think that could be problematic about that witness?
And Mark's right. So the manager is likely going to defend what they did, and the question to yourself as not only as the attorney for Cafe Bonjour, but is how is that going to play to a jury? How is a jury going to see and view that? And that goes to Dakota's point of likability. Yeah, I mean, likability is everything with trials. I mean, I had a case where I the facts were somewhat questionable, but because the defendant was completely unlikable, I won the case.
Yeah. And that kind of thing happens all the time. And with mock trial, it is all about presentation, and we're not as judges determining who should win based on the merits. It really is
Mhm.
about the presentation of the case, but it still matters. It still matters when we're looking at a witness and we say, okay, this witness did a really good job, but also this witness came across in a way that would have been very appealing to the jury.
Right, and that goes to the witness's presentation of that character. Are they trying to be unlikable, or that are they trying not to be unlikable where they could be unlikable? Or if you're the attorney, how do you handle the fact that the witness is not likable? Or if you're the attorney for the if it's your witness, how do you handle the fact that that witness is not likable? How does your advocacy change to help maybe rehabilitate their character a little bit, or make them a little bit more likable? Things like that. That all that goes back to advocacy, and that's what the judges care about.
Yep. Right. So Maria said if other workers are able to agree on unfairness coming from the manager a lot of the time, yeah, and that would be also pretty effective is to have another employee of Cafe Bonjour as a witness who's saying that, yeah, the manager does A, B, and C to the employees all the time, and it could really make the manager look bad in front of a jury if those things are seen to be unfair or just not very nice, for lack of a better term. Okay, so then let's talk about when should you get the judge's help when you have a difficult witness. And I think every judge has a different perspective on this, but I'll give you mine and then Kevin can give you his. My perspective is I want to see the attorney try to control the witness, like really give it a good try. Try for several rounds of questions. Change the wording of your question to see if that helps. Maybe change the subject and then go back to the question you were trying to get an answer to. I want to see the attorneys making at least, I'd say, two or three efforts to control the witness before objecting to me as non-responsive. So that's my perspective. Kevin, what do you think?
Yeah, no, that's good. I mean, and sometimes the witness is just being non-responsive to be non-responsive, and as the presiding judge, I don't stand for that. I want the trial to move along, and a witness who's being obstructionist for dilatory tactics, or just to show that they're being their character and being combative, then the point's made, but we have to keep things moving. So that's you know that's part of that as well. But again, with what Jamie said, yeah, that's absolutely correct. Part of this is trying to show how can you control a witness? How do you respond when the witness does not respond in the way that you want them to?
And then, yeah, you certainly want to get an answer to your question. You want to prove your case, but you also have to keep in mind that the judge and the jury, or the presiding judge and the scoring judges, are going to lose patience if you're going on for 10 minutes trying to get an answer to the same question. So it really is a balance there that, like we were saying, try it a couple different ways. And if it's still not working, then objecting is non responsive, if that's appropriate. That can be the time to do that, just to move things along. Okay, rules of evidence. I'm going to go pretty quickly through this because I know you're going to be spending a lot of time, or probably already have, understanding the rules of evidence for the case. But reading and understanding the rules of evidence to make effective objections is really important. And we're going to talk a bit more about objections. It's kind of my favorite thing to talk about in these clinics. So this is sort of the baseline for it. But here's some questions for you, because you, as mock trial participants, and us as lawyers who used to be law students, spend a lot of time learning the rules of evidence, but we don't always learn a lot about why there are rules of evidence, why they matter. And so let's talk about that a little bit. So, first of all, we all know that evidence has to be relevant in order to come in. But why? Why do we think that is required? Yeah, what Victoria said is absolutely right. It's just a waste of time if it's not relevant. I'm a person who, in my personal life, does tend to go off on tangents sometimes. I'll just be in a conversation and then I'll see an interesting bird in a tree somewhere and then I'll start talking about the bird. That can be very interesting to me. But if it's a very direct conversation about something that doesn't involve a bird, then talking about the bird in the tree is not relevant and it would waste everyone's time. So even if it's interesting, it doesn't mean it's relevant. All right, the next is why shouldn't we be allowed to rely on hearsay? Because, boy, if we could, it would make all of law a lot easier to try. Like any case would be much, much easier to try if there wasn't a hearsay rule. But why is it important that hearsay evidence not come in? Yeah, so I think this is a group of students, but it starts with Annika. Hearsay is basically just he says, she says, and it's not factually supported. That's right. I could say my next door neighbor said that the bird in the tree was blue, but why would you believe me? The next door neighbor's not there. They're not under oath. So there's no reason to believe that. And Keller also said you can't verify it. So, yeah, that's exactly true because we're relying on what someone said, someone else said. It's just too many steps removed, and there's really no way to determine if it's true or not. Okay, and then next, why shouldn't evidence of settlement discussions come in? So this doesn't come up a whole lot in mock trial, but in the law, cases, at least civil cases, are undergoing settlement discussions throughout the entire life of the case. And by the time you get to trial, sometimes you're pretty close to settlement, sometimes you're nowhere near it. But there is the rule of evidence that says that you cannot discuss any efforts to settle or negotiate or anything like that at trial. Why do we think that would be? And I'll make a bit of a fact pattern for this. Let's say that in the case we're talking about, Jess is asking for $10,000 in damages, and that's the ask that she's going to make to the jury. Let's also say that during the case before trial, there have been some settlement discussions between Jess and Cafe Bonjour, and Cafe Bonjour offered $500 to settle. And Jess said, no, but I would be willing to maybe settle for $5,000 if we don't go to trial. So those are the settlement discussions, but the damages ask at trial is $10,000. So why shouldn't the settlement discussions come into evidence? Kevin, what do you think?
So Victoria said that for the cafe, it can make them look guilty for trying to settle, and for Jess, it can make them seem like she doesn't need the 10,000. So that's is essentially correct. So basically, at trial, your job is to establish make sure that the evidence that you submit to the jury for their consideration is relevant and it's accurate. And in settlement negotiations, that is trying to resolve the dispute without having to go to trial and go through the process of going piece by piece by piece to establish that. Introducing that evidence of settlement discussions basically is trying to say that the parties were trying to establish, a point where they didn't a value of damages, and then the reason, at least one reason why I think you shouldn't include it, or it's not relevant, or should not be introduced into evidence, is that it's basically putting a placeholder in the jury's mind as to what damages should be, and that's a problem. Jamie, am I close with that?
Yeah, absolutely. It's you don't want the jury to be thinking, okay, Jess is asking for 10,000, but 2 weeks ago she was willing to settle for 5,000. So what am I doing here? Like they should just settle for 5,000 if that's what's happening. So I think it really does prejudice the jury against possibly both parties coming into it. It just muddies the waters entirely. And there's just really no point in bringing it in because the damages should be based on actual facts. Like if this were going to be in trial and you're proving damages, you're bringing in evidence like the amount of Jess's rent and her paychecks and what other bakeries were paying. And then typically you'll have someone analyzing that and determining, okay, all of this taken together should add up to 10,000. And settlement discussions are really just here's the amount of money that I would be okay with if it meant I didn't have to go to trial. So it's really just taking away the nuisance of going to trial at all. Okay, and then why shouldn't a witness be allowed to speculate? I mean, we know that you can object as speculation, but why? Why is it important that you keep a witness from speculating? Yeah, so the witness should not be allowed to speculate because not only is it objectionable, but the testimony that's speculation is also taken as a fact for the jury to consider while it isn't. That's right. I could speculate all day that, let's see, that alligators descended from dinosaurs. And I don't know where that came from, but let's just say that's my speculation. I think I'm right. I think that's probably true, but I'm not an alligator expert. I'm not a dinosaur expert. And I don't have any personal knowledge of whether that's true. So who cares what I think? Who cares about my speculation? It's not fact. It's not something that the jury would be able to use in helping to decide the case. So if I instead brought in a paleontologist to testify that based on 35 years of experience, alligators descended from dinosaurs, suddenly that's not speculation and it's way more it's a much better fact for the jury to be able to rely on because it is an actual fact instead of just speculation. And that kind of goes to the last bullet here. What's wrong with a lay witness providing an opinion? We do this all the time in our regular lives. Almost everything we say is an opinion. So why in court is that a bad thing? And again, it goes back to because the jury needs to decide a case based on facts, based on their perception of the facts. And so that's why we have the rules of evidence is to keep all this speculation and opinions that are not based on expert knowledge, things like that out. Any questions about any of this? I think it's always good to understand the why behind the rules of evidence because sometimes they seem really random. Okay, let's go on to objections. And actually, Kevin, let's start with you, and then I'll give my perspective as well. In mock trial, what are your general impressions of objections and how students handle them as when you're a presiding judge?
You object too much. That's where it starts. Does it actually hurt your case or is it neutral? So if it actually hurts your case, okay, that's when you would start thinking about maybe should I object? If it's neutral, you really shouldn't object. Objections, so have you already lost on a similar objection? If you've already lost on it once, why would you argue it again? Why would you make that objection again? The judge has already said no, I'm not going to agree with you on that objection. I want the witness to elaborate on that. I want them to explain it, whatever. Um, has the judge been overruling similar objections by other counsel? So if the judge is telling them I'm going to allow this type of evidence, why would that not apply to me? The judge is trying to set the tone for how he or she wants the evidence to come in. So those are those two last points are pretty clear, when and it takes you paying attention not only to what you're doing as your job as attorney, but what the other team is doing as they are presenting evidence, and what your colleagues at your table are also doing as they're presenting evidence. Um, it really does go back to the question is, does it actually hurt my case or not? And then what is the judge allowing? So, is the judge is it's like watching any sporting event where there's referees involved, and in watching those sporting events, you'll see that the refs are allowing certain types of conduct versus other types of conduct. Same thing applies to mock trial. What is the judge allowing? What is the judge not allowing? What type, those sorts of things. Figuring out who your judge is and what their personality is, that's a key part of advocacy, and knowing how to do that and working within those limitations, even though that they are not universal to every types of trials. The only thing that matters is who your judge is that you're before at that moment, and following those quote unquote unwritten rules. That's advocacy. That will make itself clear to the scoring judges, and that's how you get points. And points are how you win trials for mock trial. So, can you add an explanation or just state your objection? So I'll let Jamie explain the actual mechanics of making an objection, and how to do that well. Um, but and this kind of goes to the last point on the slide, but the objections do not count against your time, but they do count against your judge and the patience of your jury. So if you object a lot, you're not going to that's not good advocacy. Good advocacy is understanding what a proper objection is and when to object. Focus on the when to object. It's not enough to know that, oh, I can object to this because XYZ. It's knowing when to object. So I'll let Jamie kind of go into the mechanics of actually how to make your objection and things like that. But Jamie, if I miss anything, please feel free.
Yeah, I agree 100%. I the most effective mock trials for me are the ones where with the fewest objections. And that's not because the attorneys aren't good at them and the attorneys don't know the rules of evidence. It's because the attorneys are thinking long and hard about, I'm only going to object when it really, really matters to the case. Or I'm only going to object if this cross examination is going off the rails and I feel like I need to break up the rhythm a little bit. Sometimes that can be a valid reason for an objection. But honestly, most questions that your opposing counsel asks are probably objectionable in some way. Most of the questions you ask are probably objectionable in some way. That goes for every lawyer. You could find a rule of evidence that governs that objection. But I don't for me, it doesn't show good advocacy just to prove that you know the rules of evidence well enough to object to every question. To me, it shows good advocacy to know that you know that, but that you're saving them for the ones that really matter. So I completely agree with Kevin on that. I'll share a little anecdote. A trial that I was in earlier this year was one where I think for the entire week-long trial, we maybe had 4 objections total through all the testimony. It was just a very low objecting trial, which is great. But when my witness was on cross, I was just annoyed at opposing counsel. I don't even remember why. I was just annoyed with the way he was asking questions. Or it wasn't cross, it was on redirect. And he asked a leading question, and I objected as leading, and the judge overruled it. And I know that was because it was clearly a leading question. It was redirect. And so you can't use leading questions on redirect, just like you can't on direct. But the judge, I think, kind of saw through me and was like, why are you objecting to this? Who cares? Like, who cares if it's a leading question? Because it wasn't an important issue. I think it became very clear to him that I was just objecting because I was annoyed. And that's not a good reason to object. So just something to keep in mind. As far as the mechanics of objections, when I'm presiding, I typically tell everyone in the pretrial that the way I handle objections is stand up, make your objection, and then like say basically what it is. So objection hearsay, objection speculation. And then I'll hear a response from opposing counsel. And then I'll go back to the objecting attorney to explain their objection. And that's it. I will almost never hear more argument than that because that's my preference. I also tell students that there are some objections I'm going to rule on without hearing any argument at all. Things like objection relevance, when it's clearly not relevant, I might be able to just rule on right there and then. And so I know other presiding judges will lay that out too, how they prefer to handle objections. But I think in general, the way I'm describing is the way it generally should go in mock trial. Stand and make your objection. The judge will hear a response. You give your response. And then if you want to continue arguing beyond that, I would ask permission to do that instead of just arguing. So that's, yeah, I think that's my preference. It's just one round of back and forth and then ask for permission if you want to keep arguing. Kevin, what's your preference on that?
Um, I'm when I'm a presiding judge, the format's pretty standard as far as objection, state why, the other I'll give you the other side a chance to respond, then I'll go back to you, and then I'll rule because that's what the judges are instructed to do when we have, our judges training is that because we want to move the trial along. So just know that the an extended back and forth is not going to be forthcoming. So you have to be able to clearly and succinctly present whatever you're objecting to and why you're doing it, and just and go from there. So, but yeah, everything Jamie said, I agree with.
Now let's move on to anticipating objections, and we're going to have a little discussion on this. So yeah, and I think what it says here is true that a good team responds to objections because, of course, you have to, or else you withdraw your question and move on. You have to respond to the objection. But a great team anticipates what those objections are going to be and prepares for them. So, like we were talking about with the proof chart, you might know that some of the evidence that you want to bring in is going to elicit an objection, or it should if you're up against another good team. And so when you're preparing, you can, in that issues column, anticipate what you think the objections are going to be and how you're going to handle them if they come up. And that is very much something you can do ahead of time as you're preparing. So here's an example. So let's say Exhibit 3 in the case we're talking about is Jess's employment agreement. Now, if you're Jess and this is coming in through the defendant, through Cafe Bonjour, what objections could you make as Jess to allowing this employment agreement to come into evidence? Any thoughts on that? Okay, so Kevin said, are there authenticity questions about the document? Yeah, how do we know it's the authentic employment agreement? So that's a really good objection to make. So let's move with that one, and we might have other objections, but so let's say you're Cafe Bonjour and you really want to get the employment agreement into evidence. And I'm Jess, and I say objection, lack of authenticity. If you're Cafe Bonjour, what would your response be to that? And again, we're just making stuff up because we don't have the full fact.
Mhm.
But what do you think a possible way to respond to an authenticity objection in this case would be? Okay, so again, making stuff up, I could say as Cafe Bonjour, this document has been kept in the ordinary course of business. It's been in our filing cabinet. Maybe I'm the witness who is in charge of keeping documents in the filing cabinet. So there you would be able to point back to that testimony that showed that it was an authentic document. So it could be something like that. So then there's just some other thought exercises here. Like, are there any situations in which Jess might want to actually introduce that exhibit? There could be. And then,
So here's something that I've seen done that some of the more successful mock trial teams have done is that they will basically pre-admit that at the beginning of trial. And what they'll do is they'll ask opposing counsel if they are okay, if opposing counsel would agree to them admitting it before trial. And that presumes that there are no questions about authenticity or anything like that. So for our hypothetical is if there are questions about it, probably not. But you can if it's pre-admitted before trial, you can use that in your opening to be like, here's the jury, here's the document, it says this, things like that. So that could be a situation where you would want to introduce the exhibit.
yeah, yeah, definitely. Always something to think about. Like, can we try to pre-admit this? And maybe they'll say no, but you never know because you're not going to know who you're up against and if they're prepared for something like that. So why not try? That definitely makes sense. Okay. So anticipating objections. So again, let's try to think about what objections you would make in these situations. So we're on Jess's direct examination. So the plaintiff's case in chief. You're the attorney and you ask Jess, have you ever met the baker at Cafe Au Revoir? So let's say Cafe Au Revoir is a competitor of Cafe Bonjour. Jess says no. The attorney asks, have you ever heard anything about the baker at Cafe Au Revoir? And Jess is ready to say, oh, yeah, what I've heard from folks in the baking industry is that the baker at Cafe Au Revoir is not the most trustworthy individual. If you were the defendant's attorney here, how would you object to that attorney's question?
So relevance that's a good objection, but is there a better objection? I see Anna Sophia saying calls for hearsay, and I would agree with that. Now is there an except would there be an exception to the hearsay rule that would apply here? Maybe that's going a little bit further than what you had anticipated, Jamie. So sorry about that.
No, it's fine. But yeah, I think this would definitely draw a hearsay objection because the only way that Jess can answer that question is to rely on hearsay information because it's basically what do other people know about this person that Jess does not personally know. So yeah, okay. Let's look at this other scenario. So let's say that we are on the direct examination of the Cafe Bonjour manager. So we're in the defense case in chief. Cafe Bonjour's manager asks, did you ever see the cake that Jess claims to have baked for the VIP customer? The manager says yes. The attorney asks, is there any way for Jess to prove that that happy birthday was written on that cake? So that's the question. Is there any way that Jess can prove that happy birthday was written on the cake? What kind of objection would you make to that question? Okay, so I see speculation, and yeah, that's definitely one way to go with that. Because how would the manager know if Jess could prove that? The manager doesn't have those facts. That would just be pure speculation. So that is one good objection. There's one other one that I'm thinking of. Does anyone else know what other objection could be appropriate here? So relevance, yeah, it might be irrelevant depending on where the examination is going. And we don't really know enough about where this would fit in the scope of the bigger examination, but there might be a relevance objection. The other one I was thinking about is that it calls for a legal conclusion because it's asking this witness who is not an expert, who's not an attorney, how could Jess prove a really important element of this case? The manager isn't going to know that because that's something that an attorney would know. And so calls for a legal conclusion could be something that you could also object to here. There could be others too, but those were the ones that I had pulled out. Okay. Very quickly, another objection that tends to not be utilized that often is the Rule 403 objection. And that's if there is evidence that we know is relevant, so that's really not in question, but that could cause so much prejudice, confusion, or waste of time with the jury that it's really not appropriate. And so Rule 403 is a balance beam. It's saying, okay, you've got relevance on this hand, but then you've also got prejudice on this hand. So if the prejudice is worse than the relevance, then it can still be kept out. And so that's always something to think about because let's say you're talking about Jess's gambling problem. It's clearly relevant to damages, like we talked about, because it's another reason that Jess might be going broke other than just losing her job. But let's say her cross examination starts going into areas about the gambling that are just making Jess look terrible in front of the jury. So something like, didn't you once leave your baby at home without a babysitter because you had to go gamble? I mean, it's relevant because it talks about the gambling problem, but it would also make Jess just look like a monster in front of the jury. And so, if that kind of questioning is happening, then definitely objecting on the basis of Rule 403 and saying that the prejudice outweighs the probative or relevant value of the testimony is something that can be very effective in that situation. Kevin, anything to add there? Is that an objection that you've used in your practice or that you've seen used in mock trial?
Um, so I really didn't use it. I really didn't use it in my practice. But I haven't also really seen it in mock trial practice. So you're more likely to see it in mock trial. So it's that's where really knowing the rules comes into play, and it does show good advocacy by knowing the rules. Again, but yeah,
Okay. So then making clear objections, yeah, and it depends on the judge's preference, and the presiding judge will sometimes tell you in pretrial what they prefer. My preference, like I mentioned before, is that the objecting attorney stands up and just gives a one-word description. So objection speculation, objection hearsay. I don't usually want to hear the whole objection right up front because that tends to take a while. Because, like I said, sometimes I can just rule on the spot. But it's it's really important to be able to identify what the objection is as opposed to, and this happens I think with younger lawyers all the time too. You end up getting really good instincts about, oh, this is objectionable, I know this question is bad, and so you stand up and object, but you don't necessarily know why it's bad. You just have the instinct by now because you've done this enough that, oh, that's not a good question, it's objectionable, I'm going to object. But if you object without knowing the basis for the objection, then there's really nothing that the judge can do, especially in mock trial. Like we need to overrule or sustain objections based on the argument around the objection, or at least the identification of the objection. And so it's definitely not enough to just stand up and say objection. Like your judge is going to ask you, what's the basis? You're going to want to hear argument. And it's also important that you don't let your opposing counsel get away with just giving a real short and non-descriptive explanation for why, like for example in this bullet, why it's not hearsay because it doesn't meet the definition of hearsay. Okay, that might be true, but you are going to want to explain why it doesn't meet the definition of hearsay. Like what part of hearsay is not met by that objection. And so, yeah, just letting your opposing counsel parrot back the definition is not going to be enough. And you should call them out on it. When you get to respond again, you should say, opposing counsel didn't address the substance of the question. And we still believe it's hearsay because XYZ. So something like that. Okay, and then finally on this, and then we're going to move for just a few minutes to the judge's survey that I mentioned at the beginning, is pay attention to the judge. I tend to show what I'm thinking and feeling on my face. I use my hands a lot. Every judge is different. But if you are arguing objections and if the judge is giving guidance in some other way, pay attention to what they're doing and what they're saying. Something that a lot of judges do in mock trial, if you make an objection, like let's say you say objection speculation, and the judge thinks about it and says, I'm going to overrule that objection. Okay, that phrasing is kind of telling you that, okay, maybe there's a different objection I can make because maybe it wasn't speculation, but maybe it's hearsay. And the judge is kind of giving you a clue of, I think you're right that there's an objection, but I don't think you made the right objection, if that makes sense. So keep your ears open and your eyes open for things like that, because sometimes judges will give you little clues. And then importantly, on the other end of that, if the judge is clearly not buying what you're selling, consider changing tactics. So you keep arguing to hearsay and the judge keeps overruling that objection. So for whatever reason, the judge just doesn't want to entertain hearsay objections with a particular witness or a particular scenario. Just stop making that objection. Like it's that simple. You don't have to convince the judge that you're right because it's an advocacy competition. It's not being judged on the merits. So there is nothing wrong with just changing your tactics in the middle of your examination. And like we talked about before, and this is really important, don't object just for the sake of objecting. I don't know of any presiding judges that will give points just for teams that just keep objecting just to show that they can do it. We're really looking for the good advocacy of saving objections for when they're really important. Okay, so I'm going to pause here and see if Kevin has anything he wants to talk about or if y'all have any questions before we go to the next PowerPoint.
Going back a couple slides to the point that good teams anticipate objections. So one thing that can happen is whenever you make an objection to something and a judge may say you could clean it up on cross. So basically what that means is what the judge wants you to do is basically just address that on cross-examination. Now, in prepping your witness and your cross-examination questions, if it's something that you feel like you can just address through cross, even though there's a question that was asked that's objectionable, and you can clean it up on cross, you may want to consider not objecting in that case and just addressing that point on cross and just saying, and then when you address that on cross, you say, the opposing counsel asks you this question, however, XYZ, and that could be one way of making sure that you're communicating to the judge and jury that yes, I know that there was an objectionable question. I didn't object to it because I wanted to address it on cross. You would do that, especially if the judge has already given the instruction just to clean it up on cross, because that goes back to the point that the judge wants to move the trial along, and it's easier to do it that way than sitting through a mound of objections. Jamie, any thoughts on that?
Yeah, I think that's right. It also goes for if you are crossing a witness and the witness says, "Can I finish my answer?" or "Can I add to that?" And you can say, "No, you can do that on redirect," or your attorney can do that with you on redirect. like it's just changing tactics a little bit and understanding that there are other ways to go about handling witnesses in a mock trial. And so my point is a little bit different from Kevin's, but is also about how to change tactics on the fly if you need to.
And
Because, go ahead.
oh, sorry, I thought you were done. I just Maria had a question in the chat. Sorry.
Okay, yeah. So Maria asks, if you make an objection and the judge gives a hint that there could be a better objection, would you proceed to say the correct objection right after if you're able to think of it on the spot? So, yes, if you can. So, let's say the situation that I was talking about before, you say objection speculation. The judge says, I'm going to overrule that objection. And then you realize, like, oh no, that was a hearsay objection. Then you could say something like, in that case, I'd like to object based on hearsay. And then that is usually going to be fine. And the judge will entertain that objection right then. Um, that's how I've seen it done. Kevin, is there anything else you would add to that?
Nope, nope, that's right.
Okay. All right. Any other questions or anything else we want to discuss before we move to the next PowerPoint, which will be much shorter? Okay. All right. So we're going to go through this pretty quickly. We'll get to as much as we can. And this is really just, we've been talking this whole time about how every presiding judge is a little bit different. But this is a survey that we did 3 years ago of judges who very frequently preside in mock trial. And we just wanted to get an idea from them on what are the things that you see that you think are very effective? What things do you think students could do better? And we thought it was very interesting to see what the judges agree on, what they disagree on. And so we'll just give you kind of an overview of the things that we found. Okay, so first of all, again, like I said, this was back in 2021. We had 17 respondents that were all on the mock trial presiding judges list. And so that means that people who very frequently preside over mock trials, because just for some inside baseball, you can't come into judging mock trial for the first time and then immediately be a presiding judge. Typically, you have to be a scoring judge at least a few times to be able to be a presiding judge. So they're definitely more experienced judges. So what we found based on those 17 of the respondents that we got was that almost all of them, 82%, had presided over more than 20 mock trials. So these are very, very experienced presiding judges that we're talking to. Okay, so as far as pretrial, which of these things did these judges find helpful for a team to do during pretrial? And the most popular response was if teams asked to pre-admit certain exhibits. And I think that's because it shows good advocacy that you're covering that in pretrial rather than spending time on it when the time actually counts against you. And if you can get certain exhibits pre-admitted, then you know you're not going to have to fight about them afterwards. So that's a very effective thing to do. You don't want to go up there and say, we'd like to pre-admit all the exhibits because there's no way that your opposing counsel is going to agree to that. But if you know that there are certain exhibits that are pre-admittable, and you'll know that from the stipulations, then it's a very good thing to do to just ask to have them pre-admitted before trial instead of spending time on it during the trial. And there can also be other exhibits that you say, we didn't, exhibit 3 isn't necessarily pre-admittable, but we want to try and just see what opposing counsel says. Try it, just see what happens there. Also, introducing the team members. A lot of judges like that. I personally like that because when I'm presiding, I make a seating chart so that I can use people's names as I'm going through the trial. So it's helpful to me to be able to know who's who on a team. but it wasn't as popular a response as the pre-admitting exhibits. When teams asked for clarification about how objections will be handled, that's something that a lot of judges like too, because it shows that teams are really thinking about these things. Asking for judicial notice on all appropriate issues. And again, that's something that would come in through the stipulations, but just dealing with that sort of thing in advance rather than spending trial time on it shows good advocacy. The thing that the judges didn't care about too much was presenting a hard copy case binder. It's something you can do if you want to. There's nothing wrong with it. Some judges do like it, but we have access to all of the case materials just as judges anyway. And so it's not necessary. It's something you can do, but as you can see here, it's not something that really moves the needle for judges in pretrial. Kevin, what are your thoughts on this?
Yeah, I typically don't even accept the hard copy case binder because I want to see is I want to see the evidence that is being, actually introduced versus everything, you know, before trial.
Yeah. So it really is just preference. I'm never going to think less of a team that doesn't hand up a binder. It like, it's just if you have one, great. Sometimes I won't take it either. Some of the judges' benches that we sit on are very tiny or very cluttered, and we don't actually have room for a lot of stuff. So there can be all different kinds of reasons why a hard copy case binder, if you have it, great. If you don't, it really doesn't matter. And then here were some written responses that judges found helpful for a team to do during pretrial. So asking for permission to move about the well. I think almost all teams know to do this, and it is good to get that permission ahead of time. General housekeeping, calling the court's attention to anything outstanding that you need to deal with. Um, and then we had this response that I enjoy when teams attempt to inject a tiny bit of substance into pretrial, like drawing attention to a stipulation. So, yeah, so knowing that it's not just introductions and moving about the well, but actually starting to talk a little bit about the substance of the case because there is a stipulation or pre admitting an exhibit. Okay, now let's move to opening arguments. So, based on our survey, the two most popular things that the judges said that attorneys or mock trial attorneys can do during opening is presenting themes and speaking without notes. And so, presenting themes we talked about before, it really does help set apart a good team from a great team, showing that you have really good command over the case. You understand it well enough that you can see the whole forest for the trees and see what the theme is. Speaking without notes, again, it's not required. You can get up there and speak with notes in hand. You can have them in your hand and refer to them if you forget or lose your train of thought or something like that. Some teams will just read from notes because maybe they're newer teams or it's an attorney who has never done the opening before. All of that is permissible. But the teams that get scored the highest in opening are the ones who can give their opening argument without any notes. Previewing the evidence and testimony, that's very important for an opening to tell the jury, here's what you're going to see. And then in closing, to come back and say, okay, yeah, we fulfilled our promise. Here's what you saw. And then the least popular was introducing the trial team. It's certainly something you can do. There's nothing wrong with doing that. But if that was already done during pretrial, it is not necessarily something that needs to be repeated during opening. And, it's just a team preference. But our judges found that it wasn't as helpful as some of these other things. Kevin, what are your thoughts on openings?
Yes. So the presenting themes is the most common thing that I see that good teams do. It's not just that they do it in the opening argument because typically what'll happen is they'll say like they'll use it as like the very first words they'll say, but then they won't refer back to it in like the other parts of the opening or in the presentation of evidence or in closing if because if I'm a scoring judge and I hear that, I'm like, okay, I'm writing the theme down. The theme is this. I want to see how that translates throughout. It's not enough to just say it. You actually have to follow through on it. Um, Speaking without notes in opening, yes. Um, Absolutely agree with that. Previewing the evidence and testimony, that it's helpful to do that because it helps plant the seed in the jury's mind on how you want them to start thinking about the evidence, especially if you're going first, because it allows you to set the tone before the other side gets to do that. Um, so yeah, but yeah, I agree with everything else Jamie said as well.
And then we had some write-in responses. The first one was speak clearly and slowly and enunciate. Yeah, I tend to talk a mile a minute if I don't check myself. And it's something really important when you get into court that, and this is something you should practice and get feedback on, that you want to make sure you're understandable when you're talking. And speaking slowly is a big part of that.
And I will also note that some of our older judges, it's also speaking with appropriate volume so they can hear you. Because if they can't hear you, they can't score you.
Yeah, yeah, that's a big part of it too. And the second to last bullet point, I think, is a good one. Be compelling and engaging through varied tone of voice and engaging demeanor. And that's one of the things I feel like most presiding judges, if we had our eyes closed, could tell you if a student is reading from a script or reading without or speaking without notes. Because when you're reading from a script, your voice doesn't tend to modulate or change or do anything interesting. And if you're talking without notes, then it does. And so that's something to keep in mind when you're practicing your opening, when you're practicing your closing, is making sure that you are modulating your tone of voice and it's more like a conversation. I think a good opening really is a conversation with the jury. Um,
Now, if you're now in opening arguments, if you do happen to use notes, what I've seen what I've seen other speakers do just in other contexts is they will underline or they'll underline keywords to emphasize that will note when to modulate their voice. If you go to the Bush Library, you'll see a lot of his speech cards where he did that throughout his speeches, where he'll like underline like certain words or phrases to change how his inflection of voice. If you're going to use notes on opening, which we don't recommend, or throughout. But if you do use notes, that is one way to get around that. I did want to raise that.
yeah, yeah, definitely. And another thing about notes too, like let's say you're an attorney subbing in for another attorney who's sick, and that's the attorney who usually does the opening argument. You don't have it memorized, but you basically know what the gist of it is, what the themes are. Have a note card with just a couple of words on it that gives you a map of where you need to go, but isn't reading word for word what the script is. And then you can just talk. You can have that conversation that we talked about. So if I saw an attorney doing that and just had a note card that they kind of held by their side and glanced at every now and then, to me, that is giving an opening without notes. That's basically just you're peeking at something once every couple minutes. That to me, that's good. I think that's just as good as giving it without notes. So that's something to think about too. Okay, so let's talk about direct examination. Kevin, do you want to start us off on this one? So, what factors distinguish a good direct from a great one?
Right. So, when you are giving your direct examination, the most important thing is, at least from what our presiding judges have kind of have indicated, controlling a rambling witness is crucial because it focuses the ability to do that shows that you know how to advocate for your side. And then departing from rehearsed testimony as needed, because so the witness statements, the witnesses memorize those and they go up to the witness stand. So the witness knows them, the attorney should know them, the other side knows them. So what you're essentially doing is you're having a conversation, but and as you're having that conversation, it's like, okay, I've heard this story before. I know they're going to say this, this, and this. However, whenever something comes across that doesn't translate to the way you think it should have been, it comes across, that's when you depart from that and ask a question to get them back to where you want them to go. Um, that's a really important aspect of a good direct examination. Not sounding overly rehearsed, that's also very important. There reading reading directly from a piece of paper your questions is one thing, and it's not really advised because you can do that, but it doesn't get you a lot of points. Asking questions um, that sound like that sound kind of prepackaged will get you points, but it may not get you the maximum amount of points. But engaging in a conversation that sounds natural with your witness, that's what will give you the opportunity to gain the most amount of points. Emphasizing important testimony, it's pretty important, and basically highlighting, verbally highlighting it, drawing a circle, that sort of thing. That will allow you to gain more points than if you just, let a key piece of evidence kind of go by unhighlighted, and not relying on notes. Um, it's also it's also pretty important. Now, the scoring sheet that the judges are provided kind of goes through, how to score teams when they use notes, and it's kind of on a tiered system. So if you use notes sparingly, you can still get up to about to anywhere between 7 to 8 points, out of 10, which is pretty good. The teams that but the teams that get that are most successful, they don't rely on notes because they know it backwards and forwards. So to the extent that you can do that, it's more advisable to take that approach than if you rely on notes completely, because relying on notes completely isn't natural. The point of a good direct examination is that it not only does it get the information out, it's also natural. Anyways, Jamie, if I missed anything or misspoke, please correct me.
Yeah, no, I think that's all right. And I think I like to think about direct examination as the opportunity for your witness to tell their story. And if you think about when you're with your friends and you're telling a story that maybe something that happened over the weekend or something that happened a long time ago, every time you tell that story, it's going to be slightly different. Maybe you forget a detail, maybe you remember a detail, maybe you have a different audience, so you want to present it a little bit differently. It's the same thing for direct exam in court and in mock trial, that your witness is telling their story. And so it should be conversational, but you don't have to stick to a script. The witness knows what their story is going to be, but if they decide they want to add a detail from the witness statement that they hadn't before, if they leave something out that's not that important, that's all fine. Just roll with it. And if it is important, something they left out, you can ask a follow up question about that. And that's totally fine too. So, yeah, it's just something to keep in mind. Direct examination is telling your story, cross examination is poking holes in a story, which we'll get to in a second. And then there were some write in answers about direct examinations. Just quickly, so dealing effectively with objections, and that's going to be the case for any examination, direct cross, redirect, or recross. Maintaining a logical flow to the testimony, that is really important because some of the witness statements are kind of all over the place by design. And you can, when you're writing out the direct examination, there's a few different ways you can do it. You can do it chronological. So, this happened earliest, then this, and then this was the latest thing that happened. Or there can be some other way to structure it so that it's organized. But I think being organized is important. And then, yeah, make a point and then move on. So you don't want too much repetition. And this is something I think a lot of young attorneys do. They realize, oh, this is such an important point. I'm going to make it 3 times. You have to be able to trust your audience, who in this case are the scoring judges, that if you make it once and you made it very clearly, you don't have to make it over and over again. And then getting to the point efficiently, that's kind of the same thing there. Okay, and then cross-examination, like I said before, if direct is telling a story, then cross is poking holes in your opponent's story. And so the two most important things that presiding judges found for good cross examinations or great ones: number one, using a witness's direct testimony against them, because it is so much more effective on cross examination to have the witness have to eat their own words than to tell them something that comes from you and then have them agree or disagree with it. If you're using their own words, they can't run from that. And that's very effective. And then the same thing we've talked about before, departing from your outline when the answers are going somewhere unexpected. You have to be able to pivot, to change tactics when things are going in places that you didn't expect, and think on the fly. And that is something that presiding judges are always looking for. Like we talked about before, trying to control a difficult witness before asking the judge for help. And then effective impeachment. And we're not going to go into the details of impeachment. That's something you can practice with your team. But judges do like that when you're able to do it well. On the other hand, when you try to impeach, but you're uncomfortable with how to do it, or it's not really the right time to do it, it doesn't matter, then that is something that judges sometimes look at and say, okay, that didn't work. That wasn't something that helped the advocacy. And so impeachment, just like anything else, if it's important to the case, if you've caught a witness lying on cross, that's a great time to do impeachment if you can do it effectively. But if the witness said, oh, the defendant's eyes are green, but it turns out they were really blue, but it doesn't matter at all, why impeach them? It just takes up time. And even if you can do it effectively, it doesn't buy you any points. Kevin, what are your thoughts on cross?
So cross is important in it's a chance to set the record straight, essentially, and based on the way that you think the record is, and everything Jamie said is accurate, and I agree with this list. I mean, it's there's more of an art to it than with the other parts of the trial, because it is really dependent upon the questions that are asked by opposing counsel on direct. And then it's one of those, this part of the trial and cross-examination requires the most active listening than in other parts. So you really have to be engaged with the trial, and make it, take really good notes of the questions that are asked, and then make sure that you are ready to go on the fly when they rest, or when they pass the witness to you, because that's what separates good advocates from great advocates. Is, did they pay attention to the cross, and are they ready to go when the opposing side passes the witness to you?
Yeah, yeah, agreed. And here are some of the write-in answers that we got. So dealing effectively with objections, I mean, that's going to be important. Spreading important facts through the questioning to keep the jurors listening instead of just trying to recap everything at the end. And that's certainly something you can do. Like, you might draw an objection of asked and answered if you're trying to summarize everything at the end of cross, but you can try that. But also, having all of the facts coming in through the whole examination instead of just trying to summarize at the end is good. And then lead, because cross-examination is when you can do it. The only time I think it makes sense not to lead on cross is if you are 100% confident that the answer you're going to get for an open-ended question is the one you think you're going to get. Otherwise, you're letting the witness take control of the situation, and you don't want to do that. And listen to the witness's answers. Like Kevin said, it is the most important point of the trial for you to really be listening closely because sometimes witnesses will give you an opening to a question you maybe never anticipated asking. But you're like, wait a minute, the witness just said X, I'm going to ask Y. And because you just had no idea this was going to come up. And then, yeah, just listen and think and make the points you intended plus whatever points the witness hands you. And because that can happen. That can happen with good opposing teams. It can happen with not as good opposing teams. It can happen with great ones. Sometimes something just comes out that nobody's expecting. And if that happens, run with it because you are rarely going to get that chance. But if it does, definitely take advantage. Okay. So, amount of objections. We've already talked about this. We're not going to spend much time on it. But the presiding judges were pretty split. The presiding judges were split on do students make too many objections or the right amount of objections? And those were split 50-50. The fewest number of mock trial judges thought that students don't make enough objections. And then I'll skip this because we already talked about objections. And then we will move to Kevin, if you want to explain this about redirect and recross, and we can just talk about those generally too.
Yeah, so redirect and recross it is pretty tricky. So you're at this point you are either you're multiple minutes into your time allotted, that you have, and time is precious in mock trial as you know. And on the fly, you're trying to evaluate whether or not the point you want to get across in redirect or recross is worth the time that it takes to actually do it. And that's kind of where the mock trial world and kind of the real trial world may differ a little bit. Given that you are under time constraints, whenever when and looking at the judges' responses, half of them said it doesn't impact the scoring. 29 said 29 20 they were pretty split as to whether or not it positively or negatively impacts the scoring. Again, it's an advocacy competition. So, if you are trying to make a point that has not been made before, or you're trying to get corrected on in redirect or recross, you have to consider whether or not that it is worth the time to actually get it done. So that for me, if I'm a presiding judge and the point has already been made three times before, it may impact my scoring negatively.
Yeah.
But yeah.
Yeah, I agree with all that. It doesn't matter to me if everything has been going well for your case and you waive redirect or recross. I think nothing of that. I just think they feel confident in how things are going. They don't need to fix anything. They can just move on. So my computer just informed me that it's going to reboot itself in 4 minutes. So I'm going to pause here and just see if anybody has questions or anything else they want to discuss in those 4 minutes before I boot here. So I'm going to stop and just open up the chat, or if anybody wants to just unmute themselves and ask questions. We have now 3 minutes and 56 seconds before I disappear. Will you make your slides available to us? Yeah, we can do that. I know the recording will be made available to everyone, and we can tell Melissa that we can just send the slides along with the recording. So that's fine. All right, anything else? Kevin, any parting thoughts?
Um, I guess in closing, I mean, I guess one thing I would like to say is, or I'll bring down my mic so you can actually hear me. Um, Mock trial is a lot more complex than than anything else that you can do at the high school level, as far as like compared to debate or even theater. Um, because of just how much information you're having to process instantaneously and then basically adjust on the fly. So just know that what you're doing is very difficult. But there isn't there to be successful, it takes a lot of practice and it takes a lot of attention to detail. And so for me and what I do on a daily basis, there is a lot of attention to detail that in documents that I do. So if from my perspective, if you're looking at mock trial and you're looking at the witness statements and the evidence that you're presented, go through those with a fine-tooth comb, because that will set you up for when you actually present everything to your jury. You will have made sure that there's nothing that you've missed. Now, when you actually present it, that's where your practice comes in of, do you know what you're talking about? Are you prepared? It's also a preparedness exam. So, anyways, that's all I have. I'll let an actual litigator actually go with some final thoughts and conclusions.
Yeah, I'll be really quick. I think I have 1 minute, 15 seconds. I hate the computer does this. But I just want to say, like, y'all are amazing. Like, I do this every year because it's just astounding to me to watch these teams and how well you work together and how well you can deal with really difficult, complex patterns and how confident you are in front of the jury. And, like Kevin said, it's one of the hardest things you can do on high school level as an extracurricular. And it really sets you up great for so many things in your professional life, in your personal life. Getting up and making a speech at somebody's wedding. A lot of people would be nervous about something like that, and mock trial would prepare you for that. So just, yeah, thank you all so much for being here today. Thank you for doing mock trial. And we'll make sure that you get the access to the recording and the PowerPoints after we close here today. All right. Thanks, and everybody have a good day.